Hello, beautiful souls, and welcome to my channel. Thank you for choosing our video on Singularis Holdings Limited in liquidation by Daiwa Capital Markets Europe Limited. Sit back, relax, and enjoy the ride. Is a judicial decision of Supreme Court of the United Kingdom relating to the duties owed by a bank where a person acting on behalf of a corporate customer of the bank directs the bank to transfer money out of the company's account as part of a fraudulent scheme. The principal issues in the case were whether the bank had breached its duty to its customer by transferring the monies despite the suspicious circumstances surrounding the transfer request, and if so, whether the claim of the customer against the bank was precluded by the fact that the fraudulent acts of the director should be attributed to the customer so as to bar the claim of the customer against the bank. The Supreme Court upheld the decision of the Court of Appeal, which had held that on the facts that the bank had breached the duty to their customer, and the fact that the fraud was perpetrated by a director of the corporate customer did not preclude the claim by that corporate customer against the bank. Practical Law reported that this is the first decision where a bank in the United Kingdom had ever been held to be liable for breaching their duty to scrutinize customer transactions for possible fraud. With the groundwork laid, let's now examine facts and its connections to our previous discussions. Singularis Holdings Limited was a company incorporated in the Cayman Islands which was a personal asset holding company for Mr. Ma'an Al-Saini. Mr. Al-Saini was both the director and shareholder of Singularis. Singularis held a bank account with Daiwa Capital Markets Europe Limited which had very substantial sums of money in it. Between 12 June and 27 July 2009, Mr. Al-Saini gave 8 separate instructions to Daiwa to make payments totaling approximately S million out of Singularis account. It was accepted by all parties that these payments instructions were fraudulent. At the time of the payments, Singularis was on the verge of insolvency, and the payments were all made to other companies referred in the judgment as the SOD Group, which were owned and controlled by Mr. Al-Saini. Daiwa had raised concerns about the financial state of Singularis' financial position, as well as the freezing of Mr. Al-Saini's personal assets. Shortly before the relevant payment instructions, Daiwa's head of compliance sent an internal email to colleagues. As you are all aware, the SAD Group and some of the related individuals and entities have been experiencing well-publicized problems, including downgrades and the freezing of bank accounts. Under these circumstances, can I re-emphasize the need for care and caution in terms of any activity on their accounts with us. Singularis have reasonably large sums of client money lodged with us, and we need to ensure we maintain appropriate oversight of both further deposits and requests for payments. We should therefore ensure that any funds received relate to normal business activities and, if they are unsolicited, can clearly be linked back to their normal investment business. Clearly, any payment requests we receive must be properly authorized and be appropriate in the context of our business relationship with them. If there are any doubts or concerns, please contact compliance or legal. That warning was not heeded, and the 8 fraudulent payment instructions were paid out either without demanding any explanation at all, or on the basis of explanations that ostensibly appeared to be false. The Court of Appeal indicated that there were failures at every level within Daiwa, and the trial judge found that Daiwa had a dysfunctional structure leading to a sequence of events where everyone assumes that someone else is dealing with investigating the disputed payments, but no one troubles to check whether that is right or not. The trial initially came before Rose J., who handed down a lengthy judgment, in which she held that the bank had breached its duty to the customer, holding that any reasonable banker would have realized that there were many obvious signs that Mr. Al-Saini was perpetrating a fraud on the company. However, she reduced the claim by 25% to reflect the contributory negligence of the customer in allowing Mr. Al-Saini to act without restraint. She further held that the fraud of Mr. Al-Saini was not to be attributed to the company so as to bar any right of action on the basis of illegality. As we move forward, let's uncover the untold stories and fascinating intricacies of judgment. Daiwa did not appeal against the finding of the trial judge that they had breached their duty of care as a bank to take reasonable care, the so-called Quinsica duty, after the decision of Stein J. in Barclays Bank v. Quinsicar Limited for all ER 363. Instead, they appealed against the decision of Rose J. on 5 separate grounds where Alsani's conduct and state of mind should have been attributed to Singularis for the purposes of its claim against Daiwa. Daiwa's duty did not extend to protecting the interests of Singularis creditors, and that, in circumstances where the only persons who suffered losses were creditors for whose exclusive benefit the claim was brought, no claim lay against Daiwa. Daiwa had an equal and opposite claim for the tort of deceit which should have extinguished its claim. Singularis' claim should have been precluded by an illegality defense. But, if Daiwa was liable to Singularis, the reduction in damages should be greater than 25% under the Law Reform Contributory Negligence Act 1945. Brace yourself for a captivating discussion on Court of Appeal as we explore its nuances and implications. Sir Geoffrey Voss gave the judgment of the Court of Appeal. After reviewing the facts and the relevant authorities, Sir Geoffrey expressed the view that there were essentially 6 core issues. The first issue was whether the fraud of Mr. Alsani should be attributed to Singularis. Counsel for Daiwa strongly urged that as Singularis was a one-man company, the fraud of Mr. Alsani should be the fraud of the company. The Court of Appeal held that Rose J. had correctly applied the test set out by the Supreme Court and that Singularis should not have that knowledge attributed to it. He cited with approval the comments of Law Assumption in Jetivia. He further went on to elaborate that he did not find the phrase one-man company to be a helpful one. He noted in this case that Mr. Alsani was not the sole director, although the other directors of Singularis were described as supine. The second issue was whether, if Daiwa succeeded on the first issue, the illegality defense would bar the claim of Singularis. The key authority in relation to illegality as a defense was now. As Daiwa had not succeeded on the first issue, Sir Geoffrey declined to spend a great deal of time considering the second issue, but he added only that if he had been called upon to determine the point, he was satisfied that Rose J. had correctly applied the test at first instance. Rose J. had considered the point fairly shortly herself, dismissing it in only 5 short paragraphs, but she had formed the view that applying the test set out by Lord Torson points firmly in favour of rejecting the illegality defence put forward by Daiwa. The third issue was whether the claim ought to fail because any breach by Daiwa was not causative of the loss. The appellant relied upon Berg, Sons and Co. v. Adams BCC 661. In that case, Hobhouse J. had held that the directing mind of the company, to whom an auditor's report was directed, already knew the true facts. Therefore, his knowledge was attributed to the company, which meant that the company did not rely on the auditor's report, and the claim failed. The situation here, the appellants submitted, was exactly the same. Once Singularis is identified with Mr. Alsani's fraud, it is a dishonest company, and was not relying on Daiwa to perform its Quinsicar duty. The Court of Appeal dismissed that argument. It has already held that the fraud of its principal was not to be attributed to Singularis. But the court went on to hold that, even if Mr. Alsani's fraud were to be attributed, the claim would still be rejected because the directors of Singularis who were not acting fraudulently were indeed relying on Daiwa for the performance of its Quinsicar duty. The appellants argued, in reliance upon the decision of Evans Long J's decision in Berings v. Coopers and Libran PNLR 34, that Daiwa should have an equal and opposite claim in deceit against Singularis. The Court of Appeal rejected that contention. The court accepted that, ordinarily, a third party who was misled by Mr. Alsani's false statements into entering into a transaction would be able to recover all losses flowing from that transaction. But in this case, Daiwa was not an ordinary third party. It was in breach of a pre-existing legal duty to Singularis to refrain from making the payments whilst the circumstances put it on inquiry. Accordingly, the court held that, even if Mr. Alsani's fraud were to be attributed to Singularis, which it was not, Singularis' claim cannot be defeated by an equal and opposite claim in deceit by Daiwa against Singularis. The appellants argued that these claims were all brought by, and for the indirect benefit of the creditors of Singularis through the liquidator. The trial judge had held that there was no principle of law which entitled the court to consider what a party intended to do with the money it recovers, and that the solvency or insolvency of Singularis did not affect that principle. The Court of Appeal broadly endorsed that, holding the identity of those creditors cannot in this situation affect the question of whether the company in liquidation has a claim against Daiwa for breach of its quinsicar duty. The Court of Appeal indicated that to set aside an assessment of contributory, the appellants would need to show that the trial judge had either made an error of principle or reached a conclusion wholly outside the range of reasonable possibilities. They quickly dismissed the suggestion, saying that appellants' arguments do not get off the ground. The Court of Appeal dismissed all of Daiwa's claims in the appeal, and upheld the decision of the trial judge that it was liable to Singularis for its breach of the quinsicar duty to scrutinize instructions which would put an ordinary banker on notice of fraud. Sir Geoffrey added a few remarks in closing. He stressed that it will be a rare situation for a bank to be put on inquiry under the quinsicar duty, and that there is a high threshold. In this case, any reasonable banker would have realized that there were many obvious, even glaring, signs that Mr. Alsani was perpetrating a fraud on the company when he instructed that the money be paid to other parts of his business operations. He stressed that this case was an unusual one. He also noted Daiwa sought to rely at every level of its argument on the existence of a prior fraud as a reason why it ought to have a successful defense. But this ignored the fact that the prior fraud is an essential ingredient of the claim for breach of the quinsicar duty. Finally, he stressed in relation to the authorities that there is no proper comparison between the duties of an auditor and the duty of a banker. A banker's duties in respect of properly authorized instructions to make payments are strictly limited. The banker's duty only arises where, abnormally, the banker is put on inquiry by the particular circumstances. He approved the comments of Stein J. said in Quinsicar that trust, not distrust, is the basis of a bank's dealings with its customers. Brace yourselves for the next chapter, where we'll be dissecting Supreme Court. In the Supreme Court, the unanimous decision was handed down by Lady Hale, dismissing the appeal. In the following segment, we'll be examining significance in greater detail. Commentary on the decision has been broadly positive. Despite the wide-ranging grounds of appeal in the Court of Appeal, most of the commentary has focused upon the first instance decision being upheld and the bank being found liable for breach of the quinsicar duty. Practical Law reported that, in the 25 years since quinsicar was decided, this is the first decision where a bank had ever been held to be liable for breaching the duty under English law. Despite the comments of Sir Geoffrey Voss about the unusual facts of the case, and how liability under the quinsicar duty will be rare, inevitably banks will be concerned about being held liable for the frauds of others. Now, let's shift our perspective and explore footnotes through a fresh lens, unlocking new perspectives. Category in United Kingdom case law, category English banking case law, category Court of Appeal England and Wales cases, category Daiwa Securities Group, category fraud. Your feedback helps me improve, so please take a moment to leave a comment or review.